Can a complex multinational corporation get the benefit of a tax deduction without paying the corresponding add back to the tax income? To find out, you have to read Walt Disney Company versus Tax Appeals Tribunal, but it's 39 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Walt Disney Company and IBM versus Tax Appeals Tribunal. The citation for this case is 2024 New York Slip Opinion 02127, published by the New York Court of Appeals on April 23rd of 2024. The issue in this case is whether a complex multinational company that has parents and subsidiaries that are in different countries or different states can get deductions for royalty income being paid from a non-New York taxpayer. I'll explain all that in a few moments. The background, this is a complex area of law. I apologize in advance. The background that's helpful to understand this case is that with respect to tax law, companies don't want to pay taxes if they can help it. The more money they can keep and not spend on taxes, a dollar saved in taxes is a dollar earned. It's the same as income, right? Any company doing business in New York has to pay a franchise tax. Okay. And for multinational corporations that have companies, that have parent companies and subsidiary companies, those parent companies and subsidiary companies can be in all over the world, can be different states, different countries. And some states and some countries have low taxes or lower taxes. And the way you calculate the income with respect to how much New York's going to tax them is it's called the business allocation percentage, a BAP. We call it the BAP. And in 2003, before 2003, there was a technique that companies would try to do is what they would do if companies had intellectual property, intangibles like intellectual property, like a movie or a music or a program or software, the parent company would would transfer the intellectual property to a subsidiary in a low or no tax state or jurisdiction, transfer it to a country where there's no taxes on intellectual property. That subsidiary in that low tax area would license it back to the parent for a fee. The parent would pay that fee to the subsidiary. The subsidiary wouldn't be taxed because it's a low tax area, and the parent would try to take advantage of a tax deduction for payments made for intellectual property, for royalties. In 2003, New York State passed a new law called Tax Law 20890, trying to capture this lost tax revenue, right? Because that would sort of defeat the ability of the state to capture revenue and income. So they passed this new law basically saying that you can deduct royalty income if there's an add back of the royalty income to the BAP, okay, to the business allocation percentage. There are 3 exceptions to the add back requirement. There's no add back required if the 2 companies, the subsidiary and the parent, are included on the same combined tax report in New York State because it's already captured, the tax is already captured. No add back required. There's no add back required if the royalty is ultimately paid to a non-related company for a valid business purpose. No add back required. And no add back is required if a related member making royalty payments if that location has the location that the subsidiary is located has a treaty with America, with the United States, to pay back the taxes that are owed. In all 3 of those circumstances, no add back is required. But if a company is excluded from the add back requirement due to an exemption, it could not take the deduction. Okay? No add back, no deduction. That's what they kept saying in the oral argument in this case. The point is to reduce and eliminate tax loopholes. So what do we have what are the facts in this case? The facts are that Walt Disney World is a large corporate conglomerate with many related entities, a parent and many subsidiaries. It does business in the United States and other countries. It files a combined tax return in New York, which is an exception to the add back requirement. But outside of America, there are many subsidiaries. Okay, and there's no record, there's no indication here that any of those subsidiaries paid tax on the intellectual property royalty income generated from those foreign jurisdictions. So when Disney received those royalty payments from foreign affiliates of almost $5.5 billion, they took a deduction of the royalty payments from its taxable income, even though there was no add back. Okay, and they said we're allowed to do this because the statute is written in this way where it says that none of these add back requirements apply, and so I'm allowed to take a deduction. The New York State Department of Finance disagreed, audited Disney, and determined that they had a deficiency of almost $4 million. Okay. Similar to IBM. IBM is a similar thing. It had it's a conglomerate, many subsidiaries. It said the same kind of thing. It transferred its IP to another jurisdiction. The IP subsidiary sold back the royalties, the intellectual property to the parent. The parent took a deduction, even though the subsidiary was not paying, right? They sought a refund. The department audited IBM, denied them, and said that they owed them a lot of money. Both companies then challenged that tax decision and demanded a hearing. They got a hearing from an administrative law judge. The administrative law judge said, no, you owe the money. The Appellate Division affirms in Article 78, and it goes to the Court of Appeals. And the question here, and the claim being made by the companies are, this is discriminatory against these out-of-state companies, these out-of-state subsidiaries. It's discriminatory, and it violates the Constitution. It violates the Dormant Commerce Clause. The Court of Appeals says it does not. It does not. The meaning of the statute, they say, is clear. A taxpayer, and they underline this, they emphasize this, a taxpayer is allowed to deduct royalty payments, assuming that everything fits. And these subsidiaries are not taxpayers. So the addback and the deductions only apply if they're both taxpayers, and they're not. So by its plain term, the statute allows parent taxpayers to deduct royalty income only if the money had already been included on a New York tax return through an addback to the subsidiary's income. And here, when the subsidiaries are not New York taxpayers paying a franchise tax, then the parents don't get to take that deduction. So that's the case. Basically, it's consistent with the purpose of the statute, which is to close loopholes. It is not inherently discriminatory. It does not violate the Dormant Commerce Clause, and that's the case of Walt Disney Company versus Tax Appeals Tribunal. No addback, no deduction. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.